There's really basically two, I guess you could say, silos of major cases that you write about in the book that were where really, in many respects, new law is being created. And I want to talk about that, the general implications of that as well. How you can have new law created with no underlying explanation about it. But it's essentially COVID and religious liberty. And then the second tranche is voting rights. Let's talk about the first. It's not just COVID regulations, but it was really focused on how it impacted religious people.
That's right. So one of the, I mean, back to the point about how it undermines public confidence when there's no rationale. There were efforts to defend the court's behavior in the Trump cases as being sort of, evanescent, as being a response to this unusual hostility on the part of lower court judges to President Trump. And so, it's just about that. And that's why the COVID cases are important, because here's a context where you have challenges to state laws, not federal laws, where Trump is nowhere in the conversation and where the court is behaving similarly, where we see, the justices accepting emergency challenges to COVID mitigation measures in blue states primarily, on what end up being novel religious exercise grounds, where the court actually ends up handing down a new understanding of freedom of religious exercise in the Constitution, in the context of these, unargued, unsigned, unexplained cases. And that's remarkable, Sam, I think, in two respects. The first is, I think it puts to bed any argument that what happened in the Trump cases was somehow Trump specific and wasn't part of a broader shift in the court and how it approached this. But second, it was incredibly sort of clear just how much of a difference Justice Amy Coney Barrett made in those cases. Because, in the summer of 2020, when Justice Ginsburg is still on the court actually turns away the first slew of these kinds of claims in a case from California, in a case from Nevada, with Chief Justice John Roberts joining the four, Democratic appointees in denying relief. As soon as Barrett's on the court, her very first public vote as a justice is to reverse that, is to flip that over, starting right before Thanksgiving in 2020, where now you have a 5-4 majority going the other way, with John Roberts joining the more liberal justices in dissent, all because of, this perception that these COVID restrictions were interfering with religious exercise in ways that were unconstitutional. And that's where I think, Sam, you really start to see the gravity of the charge, that this was not just about a, one-sided set of cases involving the Trump administration, but a more profound shift in how the Supreme Court as an institution was approaching these kinds of applications for emergency relief.
And we should also note, and I don't know that it's really an issue in terms of like our audience here, but more broadly speaking, the question of whether COVID was real or dangerous or whatever, completely irrelevant in this situation. And I say that because if we have another pandemic, and it could be one where it's the virus is not nearly as lethal or have the same health implications, or it could be one like, I don't know, a novel virus that is like Ebola, where your eyes liquefy and it happens like that. We don't know. If I'm in a state government, I don't know what I can do at this point, because there's absolutely no guidance from the Supreme Court other than we're going to shut it down, based upon this notion that, like, well, people in churches, I guess, are protected from the implications of a virus as opposed to people in a movie theater, let's say. Right? I mean, yeah, that's one of the big problems here.
So, I mean, I think that's one of the problems. That would be bad enough, right? I mean, it would be bad enough if the court was intervening to block all of these COVID restrictions without explaining why it was intervening. what makes it even worse, Sam, is that it's intervening in a context in which it's only supposed to be able to rule for the challengers. It's only supposed to be able to block these policies. If the right to relief is, in the words of the court, indisputably clear. And so what's especially galling about the COVID cases is that here's a context where on the court's own interpretations of its authority, it's not supposed to be intervening in close cases. And it's not supposed to be intervening just because it happens to disagree with prior law. And yet the court is repeatedly intervening in order to move the law forward from their perspective, right? In order to change the law. That's exactly what the emergency docket's not supposed to be for, right? The emergency docket's supposed to be for when lower courts have erred so egregiously vis-a-vis the status quo, not as a way of making a new law faster. And that's where, the book has this sort of subtle, but I think pretty clear shift from the sort of the descriptive part of the book to the more critical and prescriptive part of the book. And this is where it gets hard to not be critical of the court, because it's an abuse of the court's procedural rules to do it this way. It's an abuse of the court's sort of institutional relationship with state governments. And it's all in the context in which the court is not providing justifications for these kinds of interventions. And Sam, all while it actually has cases on the merits docket raising the same questions, where if they really wanted to change the law, if they really wanted to revisit these precedents, they actually had a perfectly clean and appropriate vehicle for doing so. That's where it starts to look like this might actually be at least somewhat willful, right, on the justice's part.
So, okay, and just to be clear, to put a finer point on that, the emergency docket had been used as a way of dealing with an immediate miscarriage of the law, as opposed to, and this happens all the time, a sense that the law should evolve, either the law should evolve in a certain direction, or that past precedent had been problematic and was misdetermined. So when addressing the nature of a law or our understanding of it, emergency docket had never been really used in that way. Only when somebody more egregiously was not following the way that the law was understood by the court.
Because otherwise, how can you show that you're being irreparably harmed by law that isn't settled? Right? I mean, that's what's supposed to differentiate a court like the Supreme Court intervening early in a case versus waiting for the case to work its normal process through the courts is whether, if we don't intervene now, you, the party asking us to intervene, are going to suffer a harm that we can't fix later, right? That won't be redressed by us ruling for you 6 months, 12 months, 18 months from now. And, Sam, back to where you started, right? I mean, in a world in which we understand irreparable harm traditionally, it is impossible to see how someone can be irreparably harmed by a lower court ruling that faithfully applies existing law. Right? Versus I'm irreparably harmed because the lower court's not changing the law the way I want it to.
I can't hear the phrase irreparable harm without thinking of Bush v. Gore. Mm-hmm. And I wonder how much, and there was at least some theoretical, there was a dissent, but we were at least got to read their reasoning in that, and I would say at the very least, and it was about the least in my estimation. But how much did that notion of irreparable harm influence this new, I guess, concept of irreparable harm?
Well, I mean, I think it starts slipping not that, roughly around the same time as Bush versus Gore. I mean, I do think that you can see, especially some of the conservative justices taking a more capacious view of irreparable harm, where it's in the eye of the beholder, right? Where in Bush versus Gore, the irreparable harm was letting the recount continue from the Republicans' perspective. And the irreparable harm from the Democrats' perspective was stopping the recount.
But wasn't the justification of the justices about the irreparable harm to George W. Bush was that he had already been declared president, And if he's not now, then it's going to make it seem like maybe he's not president.
It'll harm the country, right? In the sense that there will be faith will be undermined in democracy.
No, my understanding is that the irreparable harm was specifically to George W. Bush as a candidate.
So, I mean, so Sam, that's what Scalia says later in public speeches. In the actual opinion, right, the harm that justifies the court's intervention. And let me just add sort of one piece of context. Bush versus Gore started as an emergency application in the Supreme Court, but the justices understood that they couldn't end it that way. So they actually turned it into a merits case. They actually, expedited the heck out of it. Had, what sort of passes for regular briefing on a hyper expedited schedule, held oral arguments and everything. I mean, they gave it the full 9 yards. The justification that the majority, I would say, invented in Bush versus Gore was the need to meet the so-called safe harbor deadline of the Electoral Count Act of 1887, that it would irreparably harm Florida voters if Florida was not able to certify a victor by the safe harbor deadline. And that was what justified stopping the recount. We could probably do hours on whether that was valid and persuasive analysis. What I'll say is, at least it was analysis. I mean, right? They explained the damn thing, right? Contrasted with the, last year's Alabama redistricting case, where, a 5-4 majority over a dissent from, among others, John Roberts, great fan of the Voting Rights Act, where a 5-4 majority allowed Alabama to use an unlawful congressional district map with no explanation whatsoever. Sam, in a ruling that could very well have altered the balance of power in the House of Representatives.